Last panel discussion start. We have 3 presentations and we hope for wonderful discussion after. First presentation is about bringing jihadists to justice, international criminal law applied by German high courts by Eike Christian Fezenfeld, doctor in international criminal law and prosecutor. And we'll start. Floor is yours.
Yes, hello everyone. Thanks for having me. It's of course also for me a great honor being here in this beautiful town at the Black Sea. It's the second time I'm in Odessa now. I always was looking for a reason to return, and this conference gave me this opportunity. So I hope everybody can see the slides. It may be that you sit a little bit too much on the earth, but it will work. So I will talk about a topic Professor Wilkitsky already started yesterday, and he even mentioned me. And I will try not to repeat too much, because you don't need to hear things twice. So as you it did work earlier, so. So, should I try it again? Yes, it works. Wonderful. So, as you already heard yesterday, in Germany the German Bundestag, which is the parliament of Germany, created the so-called Völkerstrafgesetzbuch, which you can roughly translate to Code on International Crimes in 2002, just one day before the Rome Statute came into force. Because of this, specific German law courts have the obligation and are authorized to try suspects under international criminal law. Even if the suspects are not German, have perhaps never lived in Germany, will perhaps never live in Germany, have not committed their crimes in Germany, it all doesn't matter. Of course, why is it? It is because of universal jurisdiction. This presentation will give you, I guess, you can't read it, perhaps more to the up, not down. Oh yeah, smaller is also a good idea. Yeah, so yeah, that's really good. Thanks. This presentation will give you a short outline of the legal framework, then we'll follow with an overview of previous and present trials. After this, I will give you a description of the factual problems the German courts are facing in these trials. And last but not least, I will give you a short outlook, a conclusion on the expected development of further cases tried by German high courts under international law. So now this does not work any longer, I'm afraid. But you can also just, okay. So very briefly, because Professor Wilkitsky already mentioned it yesterday, the Völkerstrafgesetzbuch is divided into two parts. First in the so-called Allgemeiner Teil, which are the general provisions, afterwards followed by the Besonderer Teil, the more specific provisions, which is basically like every German law is built. The investigations are led by the federal prosecutor, which is I am a state prosecutor for the state of Baden-Württemberg, and above me stands the federal prosecutor. He has his seat in Karlsruhe, which is kind of the legal capital of Germany, because also the Supreme Court is there and the Constitutional Court, and third, the federal prosecutor. It's one of his most important things he has to do is to lead investigations under international criminal law. Secondly, the federal police is also investigating these crimes, not the normal police you see on the ground, it's the feds, yeah? So the federal police. This especially shows how important these crimes are to the German public and the German government. Next thing is what is also very uncommon is that in first instance, not perhaps the district court or an even lesser court is trying subjects under international criminal law, but the so-called Oberlandesgerichte, which are kind of the high courts. Usually every of the 16 German states has one high court. These are, you must think about, like the very old, very intelligent judges, yeah, and most of them are professors or something. They try people under international criminal law in the first instance. Especially involved so far have been the high courts of Düsseldorf, Berlin, Frankfurt, and the last one, which stands right down there, but it's not on it again, is in Stuttgart. That's where I also am from. I'm from Stuttgart. So, a very brief look on the Völkerstrafgesetzbuch. It's only 14 paragraphs, but there's much written in these 14 paragraphs. In the first paragraph, you find just what you expect, the universal jurisdiction. There stands in very briefly that Germany has the obligation to lead investigations under international criminal law. Secondly, because the law is very short, it refers to the general German law. Very important is paragraph 153F of the procedural law, which makes it possible for the prosecutor not to start an investigation if the subject is neither in Germany and the stay of the subject in Germany cannot be expected. This means, for example, a very famous example is Donald Rumsfeld. I don't know if you can remember him. He was US Secretary of Defense, and he was charged by several organizations of torture as a war crime. And in the end, the federal prosecutor decided he will not start investigations, as it's very unlikely that Donald Rumsfeld will come to Germany when they start investigations. And I think that it's obvious that Rumsfeld will probably never go to Germany again. Yes? So he did not start any investigations against Rumsfeld. Another example at the moment is, now we could, for example, investigate against al-Bashir, for example. Yes? Or we could also start investigating against, for example, Kim Jong-un or something. Yeah? But it would not make any sense, as he will not come to Germany. It's obvious that this would be quite a waste of time and resources. The next three parts of the general provisions deal with acting on order, responsibility of military commanders and other superiors, and international crimes cannot lapse, which is normal for murder and also for international crimes. Secondly, it's unfortunately not working again. Sorry. I don't know why. Okay. Next one are the specific provisions. Obvious, the first one, the most important one, the gravest one is genocide. We call it in Germany Völkermord, which can you roughly translate to mass murder. Secondly are the crimes against humanity. Next one, which are the most, are the war crimes. And very recently, only I think 5 months ago, Germany adopted the Kampala resolution and incorporated the crimes against of aggression into its national law. So now we could also try under paragraph 13 of the Völkerstrafgesetzbuch aggressors. So now this was just a very brief overview. Now we come to the trials which have been conducted so far. First of all, one has to look at the data. Until now, the federal prosecutor has conducted more than 115 investigations so far. Very important, one of the most serious crimes committed in the last 30 years are out of the jurisdiction of the Völkerstrafgesetzbuch. Same applies to the ICC statute, because it's it's only the jurisdiction is only for crimes committed after 2002. So you cannot lead investigations because of the Rwandan genocide or the Yugoslavian war, but of course could be tried under normal general German law, which also has been done. So the investigations which happened so far can be divided into 3 groups, which is first Afghanistan, Kenya, and Syria and Iraq, ISIS. Yes. Just to make a very short example, I hope you can see it, that the picture on the right side, it's tankers which are destroyed. There was an investigation against a German Oberst. His name was Georg Klein, and he ordered an airstrike which was then conducted by an American F-15 fighter jet on 2 tankers and accidentally killed more than 19 civilians. And just after this happened, it came into Oberst Klein's mind that there were not Taliban at the tankers, but mostly civilians. In the end, the prosecutor didn't see any crimes committed. So next group are the so-called FDLR trials, which are trials against those crimes which happened in the Congo, especially by the FDLR. You can see now this happened in front of the High Court of Stuttgart. I also been to several of the proceedings because it was a really very, very long trial. It was much in the media, and you can see here Ignace Muavanshayaka and Straton, unfortunately his name is not on it, but they were president and vice president of the FDLR. Yeah, this was the first real pilot process we had in Germany. They were mostly charged by the prosecutor because of war crimes, and in the end the High Court sentenced them to 13 years and the second defendant to 8 years. It's by far the largest process we had so far in Germany. Because of the Völkerstrafgesetzbuch, it began in May 2011 and ended in 2015. So it took more than 4 years, which is, I know, for an international trial at the ICC or ICTR, just a normal length. But in Germany, we are used to more short trials. Just earlier this year, the OLG Stuttgart also sentenced another member of the FDLR. But to come to an important point, these are probably the last FDLR trials we have in Germany. In all these cases, the Rwandan parliament tried to extradite the accused. So they wanted to have them on their own and try them. In the past, the German courts declined this question for extradition because they said in Rwanda they may face the death penalty and they may face unfair trials. But just earlier this year, I think it was in February 2017, the High Court of Hamm said, no, now we can extradite suspects to Rwanda, which happened now to one person. He was extradited just, I think, 2 weeks ago to Rwanda. They said this subject is not facing the death penalty any longer. He's only facing lifelong sentences, which we also have in Germany. And also the trial standards of Rwanda do not conflict with European minimum standards any longer. Thirdly, what I think is also a really good argument is that the ICTR, International Criminal Tribunal for Rwanda, has extradited suspects, I think, for quite a long time, especially the lower cases were given to the Rwandan jurisdiction. So, of course, this suspect, he was quite unhappy. He wanted, of course, to be tried by German courts, I guess for obvious reasons. Now I come to the focus, which is now for the next real big group is Syria. In Syria, of course, you all know it, there's a quite heavy war, probably one of the biggest catastrophes in the last 20 years happening right now, with hundreds and thousands of dead or homeless people. And while the office of the trial of the prosecutor of the ICC cannot start investigations in Syria at the moment, at least, because neither Syria nor Iraq are members and the Security Council couldn't achieve an agreement, the German federal prosecutor, of course, can start investigations. He is not bound to anything of all these procedures the ICC is bound to. He says it's universal jurisdiction and I can do it if I want to. So at the moment there are more than 13 investigations led by the federal prosecutor against people who may have committed war crimes in Syria or Iraq. Yes, where do all these subjects come from? Most of them, I don't know if it's known in Ukraine, but in Germany we have very much asylum seekers coming from Syria and Iraq. It's only guesses, but there may be more than 2 million people have entered Germany in the last 2 or 3 years from Syria and Iraq. Most of them are still living in Germany. Just imagine, I don't know how many people live in Odessa, perhaps 1 million? Just think, double the size of this, yes, and these are people who came to Germany in the last 3 years from Syria and Iraq and also other places. Of course, imagine they're coming from war, from places where big wars happening, and just a little number of this are probably war criminals. And so far, it's obvious that this is only the beginning. Germany has realized that this is the beginning of the trials. They have created special senates at the High Court, special chambers at the district courts, several divisions at the prosecution's offices, several specific departments at the federal police. You can roughly divide these investigations into 2 groups. One, the foreign fighters and the asylum seekers. I come now to the asylum seekers, but it's unfortunately not working again. So, foreign fighters are usually German nationals who had the great idea to go on a jihad in Syria. So they usually leave for Syria and also get engaged in the fightings there. In most cases, it's because of ideologic reasons. And later they realize it's not that the great life in Syria, and they return to Germany. And in many cases, the police were already waiting at the airport for them. And it's unfortunately not working again. So, yeah, these are 2 examples. It's Harry S. He's a German national and a jihadist, and he fought as a jihadist for the IS. Down you see it's Aria L. He was born near Frankfurt, and they too both were sentenced very recently for their commitment in the Syrian war. Not again. So, I just want to show you the most important case, which happened at the High Court of Frankfurt. Also, it ended this year. The court sentences 30-year-old accused to 8 years and 6 months of imprisonment, inter alia, because of war crimes. The court came to the conclusion that he joined the war, lived in Syria in 2014, was member of a battle unit, and committed one specific war crime. The war crime was that this battle unit, they found a dead body of another soldier, and then they cut off his ear and nose of this dead soldier, made pictures of this and a film, and in the end put it on Facebook. And the High Court found this as a war crime, and according to the Völkerstrafgesetzbuch. Next group are the so-called asylum seekers. This number is, of course, quite much higher than the foreign fighters, because there are so many asylum seekers now coming to Germany, while it's only a guess of 400 German people who went to Syria for fightings. In these cases, the subjects are not German. They have never lived in Germany before. They probably will have to leave Germany in some years again, and they have not committed any crimes in Germany. So it's a really good example of universal jurisdiction, I think. Yeah, usually it's they are reported by other refugees. yeah, it's obvious for the federal prosecutor that this is kind of his next big task in the next years, because as the IS, I'm really optimistic that the IS will lose their wars, but on the other hand, this will mean that if they lose more and more, they will have to flee, and usually they don't stay there because they probably get shot immediately. So what they are doing, they flee to Europe, and quite unfortunate for us Germans, they quite often flee to Germany. So this is an example of an already nearly finished trial against a Syrian. He stands trial at the High Court of Stuttgart, and the prosecution asked just last week, I've been there, for a sentence of 7 years. I want to tell you what war crime the prosecution said he has done. He was a member of the terror association Jabhat al-Nusra, which is also one of those players which fight there with any reasons, nobody really knows why, against each other. He and other people abducted a Canadian UN employer on the Golan Heights and repeated death threats against him and demanded a ransom. In the end, this Canadian UN member was able actually to flee. So quite a brave man in the end. He also testified, of course, as a witness at the High Court. Yeah, this, the prosecutor subsumes these actions as a war crime against a humanitarian operation, which is a crime you can find in paragraph 10 of the Völkerstrafgesetzbuch. A judgment is expected next month, so if anyone wants to come to the High Court, you can come. So, we come now to the last point of my presentation. It's about the problems the German justice system is facing with these trials. One must say that, of course, first the Völkerstrafgesetzbuch was an idea, and people thought, oh, it's a good idea, but nobody actually did anything just to make sure that that the law is used. So now, still, both police, prosecutions, and courts do have very limited resources. On the other hand, prosecution and police must be quite competent to work productive in these issues. Next problem is, of course, these investigations are complex and always have a foreign dimension, and why the courts have universal jurisdiction, the police does not. Yeah? They cannot just go to Syria or Rwanda and investigate there. So what do the German courts do? They issued a large number of requests for mutual legal assistance, for example, to Syria or Rwanda, the UN, and the ICC, and we're hoping for answers. On the other hand, they interrogated, that comes on the next slide. Another problem, of course, that these crimes are not happening in New York City or somewhere, but in one of the most dangerous parts where crimes are happening, where it's inaccessible regions, several thousand kilometers from the court. And also these trials, they always have a very increased political sensitivity. Another problem also I think the ICC is facing, and any other international court, is that German people sit over Rwandans or over Syrians. These are people the judges don't really understand, and I don't mean in a language way, but I mean from a cultural or economic or social background. Next point, I already mentioned it, the trials usually last very, very long. The longest trial took 320 court days. I mean, the longest trial I've been a member to took 20 days, and I found even after 10 days I was quite bored and, let's say, a little bit tired. Yes, but just to think about 320 court days, it's extremely long. Next problem is identification and interrogation of witnesses. You don't have them in your country, you must go there, or you can do it by Skype, and you just realized how many problems can happen here if you think on the last presentation, yes? And also the high courts in Germany just faced exactly the same problems when they interrogated witnesses through the High Court of Kigali in Rwanda. Come to a conclusion, outlook. These are just 3 courts, which is the High Court of Düsseldorf, Hamburg, and this is the one of Stuttgart. It's obvious that they face very much work in the next years to come. The conflict in Syria will lead to even much more trials, and they also have to be tried under international criminal law. Peace for Syria and Iraq is not in sight. It is unfortunately just the goal of many perpetrators to come to Germany because they hope here for a safe haven. They hope that they are not found. Yeah? They hope they just look like any other Syrian. And just to so what do I want to say? Yeah, it's important that they are not allowed to think this, that they need to understand that they find no safe haven. Either, I hope, not in Ukraine and not in Germany. One problem is so far no main offender has been tried. It's only kind of normal soldiers, foot soldiers, who committed some war crimes. But they also face much more problems in the end. Yeah, what my conclusion is that at the moment, although many of my colleagues are quite disappointed because it's so much work, there is no alternative. If we are not doing it, who else should it do? It's necessary for lasting peace and security in Germany and Europe. So what I want to say, the legal basis has already been created through the Völkerstrafgesetzbuch. Thanks a lot.
Thank you for your presentation. Next presentation is about families of victims of international crimes by Malgorzata Myl, professor assistant and PhD student at the Department of International Public Law and European Law, University of Silesia.
Hello, dear guests, Judge Ušacka, Professor Gnatovskyy, dear ladies and gentlemen. Looking at the time, I will try to be brief and quick. Yesterday, Judge Ušacka and Professor Tulyakov mentioned about the victims, few times mentioned about the victims, in the context of participation and in the context of the rights. Talking about the victims, in my opinion, we should start with the definition of the victim, who the victim is actually under international criminal law. For many people, victim is just a person who has suffered harm, who was murdered, who was tortured, and this is the victim for, like the picture of the victim for many of us. Just to share my personal experience with you, last year I participated in a research program in Bosnia. I had a chance to meet with families of the people that died, and that were killed in the genocide, and that disappeared. And then I realized that those families, those relatives, are still thinking about the people, still thinking about the people that actually died. And then I realized that the crime doesn't stop. It just continue. It's not finished when the victim is found and when the perpetrators is put to the court, before the court. It just continue for the families. But starting from the very beginning, how do we know who exactly the victim is under international law? Milestone, in my opinion, was the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. It was a resolution adopted by the General Assembly in 1985, and this declaration contains the definition of victim. And according to the declaration, the victim is the person who individually or collectively have suffered a harm, so-called direct victim, but also the immediate family or dependents of the direct victims, and the person who has suffered harm in intervening to assist victims in distress or to prevent victimization. So as you can see in this declaration, it was made differentiation on the direct and indirect victims. And later on, this differentiation, this idea was followed by other international documents, was adopted in other international documents. Just to mention another resolution of General Assembly, basic principles and guidelines on the right to remedy of reparation for victims of gross violation of international human rights law and serious violation of international humanitarian law. This resolution was mentioned also yesterday, so I will just not focus on the resolution itself, just to mention that the definition of the victim was adopted in Article 8, and it's very similar to the one that was adopted in the previous mentioned resolution from 1985. I would also like to focus on the victims of enforced disappearance, since this is the top. Is it working? But it's on. Okay, now it's working. Okay. So since the enforced disappearances are the main topic of my research, and it's also very relevant to the victim issue. First, the declaration on the protection of all persons from enforced disappearance adopted in 1992, and then International Convention on the same topic. In both documents, the broad definition of victims was adopted. The convention goes even further with its regulation. It does not only cover both direct and indirect victims, but it also establishes rights of victims, and just to mention, explicit right to truth. Just a few more comments about victims of enforced disappearances. According to Article 24 of the Convention, victim of enforced disappearance is a missing person and any individual who has suffered harm as a direct result of enforced disappearance. It needs to be emphasized that in relation to enforced disappearance, family, the relatives, are victims per se. They're explicit explained like that. And international community has underlined this view many times. It was underlined that enforced disappearances, without any doubts, causes a huge suffer for the family. It was also confirmed lately in 2005 by Ombudsman of Peru, who said that enforced disappearances are one of the most serious forms of human rights violation, which breaks not only the missing person rights, but also the relatives' rights, the family rights. Serious suffering inflicted on families has been enshrined in many international documents. Just to mention the United Nations resolution of 1978, which states that enforced disappearances cause anguish and sorrow to the relatives, especially to spouses, children, and parents of the missing person. This idea was also followed by other international bodies, such as Inter-American Commission on Human Rights. In its report of 1978, the Commission emphasized that the waiting a long time for any news about the victim's fate exerts negative effect on the entire circle of the family and friends. Also, Human Rights Committee shared this opinion, for example, in cases of Maria Quinteros versus Uruguay or Igor Riashevich versus Belarus. So this was about the international human rights monitoring bodies. But what about the criminal courts, criminal tribunals? The previous tribunals, such as International Military Tribunal of Nuremberg or ICTY, ICTR, were very much criticized for the lack of proper attention to the victims. Of course, ICTY and ICTR relied more extensively on victims as witnesses, but still the punishment for the perpetrators was the main target, was the main aim of these tribunals. Only the establishment of International Criminal Court changed the position and the perception of victims. Talking about victims of enforced disappearances and ICC, I just need to be said that according to the Rome Statute, enforced disappearance are explained, are classified as a crime against humanity. there are some strict requirements that must be fulfilled, that must be that need to be fulfilled, such as widespread attacks towards civilian population, prolonged period of time, subjective elements. Therefore, ICC will more likely handle very few cases of enforced disappearances and of the victims of enforced disappearances. Nevertheless, International Criminal Court has quite a rich experience concerning victims and its rights. Term victim is explained under Rule 85 of Rules of Procedures and Evidence of ICC, and according to Rule 85, victim means person who has suffered harm as a result of the commission of any crime under ICC jurisdiction. Victims may also include organizations and institutions. Please note that there is no differentiation on individual or collective victims, nor on direct and indirect victims. So, is it then justified to include family as a category of victim? I would say yes, it is. As you can notice, the rules of procedure, it's not required that the victim is direct target. What is emphasized is that the victim must be the subject of harm. Those indirect victims may be also included to the category, to the definition, as long as this person suffers harm. And just to show how ICC comes to this to the victims, Judge Ušacka yesterday mentioned that the cases, that's actually the source of our knowledge, how the court treat victims and what is important. So just to refer to the case, for example, in Lubanga case, the topic of indirect victims arose, and in Lubanga case, both trial chamber and appeals chamber confirmed that the victim is a person who suffered harm. It was emphasized that even though harm must be suffered personally, it can be direct or indirect. Following this, trial chamber decided that indirect victims need to prove that their harm or loss was inflicted as a result of their relationship with direct victim. And in this case, chamber found this relationship, for example, between a child soldier and his or her parents. What is also interesting in this case, it was that chamber excluded from the category of victims those who suffered harm as a result of the later conduct of direct victims. Just one more thing, and I will come to the conclusion. Yesterday also the reparation was mentioned. This is of course different topic, because it's more about the victims' rights, not about who the victim is. But just one comment. Also in Lubanga case, the trial chamber in its reparation decision found that reparation may be granted to both direct and indirect victims, including the families. Of course, there are some special provisions that have to be examined before, but this is another discussion. Just wanted to point out that families are explicitly mentioned by ICC as a subject of reparation. Just to summarize, nowadays it is well understood after many years that international crimes are committed not only against some abstract humanity, but also very much against actual individuals, the victims that have not, should not be forgotten or ignored. We have to remember that the victim of the crime, it's not only the person, like I mentioned at the beginning, who died, who was murdered, who was tortured, but also the families. Of course, some people also say the society, the country, and etc., but the family as a first. And in many cases, families are denied, for example, the right to know the truth about what happened, the right to the whereabouts of victims, the receipt of remains, and etc., etc. So, in the reconciliation process, important is not only the criminal responsibility for perpetrators, but also a proper respect for victims and respect to their rights. And I think this is the current task for the international criminal law. Recognition families as a victim was just the first step. It was a great step, but first, the next step should be made by practice, implemented by international tribunals. Thank you.
Thank you for your wonderful presentation. And the last presentation of last panel is about the ICC complementary principle under the shores of states by Milana Pfeiffer, postgraduate student, University of Strasbourg.
Thank you very much. Thank you for being here. Thank you for previous presentations. I think I learned a lot, and especially this national perspective of Germany showed me that I would have chosen a different problematic if at least a majority of state parties to the ICC would have the same engagement as Germany has. Because my central problematic is the complementarity principle, but it is especially the lack of engagement, the lack of cooperation of a lot of state parties and non-state parties to the ICC. But before starting with the central problematic, I would like to make some short introductory notes about international law in general, which will be substantial for the understanding of my point. The states are the creators and masters of international law, and only the states, through their sovereignty they possess, do have the legitimate competence to originate international law. Once the legal outcomes of negotiations are ratified and signed, they are binding and impose international obligations on the state parties. In consequence, once international law is established, it gains on automaticity and is able to exist as an objective legal instrument, and in the best case, independent of the discretion of states. Ultimately, the credibility and effectiveness of international law is related to its emancipation from the political influence of states. Although, as international law cannot exist without states and derives from their actions, in the end it still remains intrinsically dependent on their political will, whether concerning financial support assuring its existence or cooperation in procedures. Especially international criminal law is a domain where objectivity, impartiality, and apoliticality is crucial to its essence of functioning. In its center stands the fight against impunity for the commission of grave crimes by following a regulated procedure in order to guarantee the right of defendants. To achieve this aim, the International Criminal Court has been founded as, and I cite the Article 1 of the Rome Statute, the first permanent institution to have the power to exercise a jurisdiction over persons for the most serious crimes of international concern, and shall be complementary to national criminal jurisdictions. The purpose of this report will focus on the second part of this article, referring to the complementary principle, and emphasize particularly the ICC's inevitable dependence on the cooperation of states. As stated in the preamble of the ICC statute, the implementation of international obligations is primarily an affair of states themselves, and only in instances of ineffective implementation does the ICC intervene, a principle known as complementarity. It sets up the interlinked relationship between the domestic courts on one side and the ICC and illustrates their interdependence. Complementarity, if used as a descriptive term, defines the relationship between international and national efforts to prosecute international crimes. But its substantial meaning can be summed up in three main functions. It can be firstly the substitutive complementarity, like in the case of unwillingness or inability of a state to generally activate its primary jurisdiction. Secondly, the substantial complementarity in the case of lack of substantive criminal law provisions. And thirdly, procedural complementarity, which consists in cooperation for investigation and enforcement of decisions. It has been considered that the wording of the Article 17 of the Rome Statute leaves wide room for interpretation owing to ambiguous terms such as unwilling, unable, or even generally. So the positive approach of complementarity has been developed and used in the most of cases. So in September 2006, the Office of the Prosecutor exposed its prosecution strategy, which I will quote. The principle of complementarity ensures the rule of law by creating an interdependent, mutually reinforcing international system of justice. With this in mind, the Office has adopted a positive approach to complementarity, meaning that it encourages genuine national proceedings where possible, relies on national and international networks, and participates in a system of international cooperation. This should not only be done on paper, but result in a real interaction by offering state support instead of just threatening them. This more constructive relationship between the ICC and the domestic jurisdictions has proven itself effective as long as states delivered at least minimum of honest cooperation. But I will take the example of the Sudanese case because it's the best example to show where there was no cooperation from the government. And so the ICC in this case, or like especially the prosecutor, proved that he also could toughen the tone and like do it the hard way. And this approach has been considered by some authors as the original antagonistic conception of complementarity. And still it illustrates all of the limits of this original antagonistic conception of complementarity. So to illustrate a little bit the case, just briefly, when the Security Council, by its resolution 1593, referred the situation in Darfur to the court. It was in March 2005. The prosecutor tried as long as possible to establish a diplomatic dialogue with the Sudanese government. But this had to stop because the Sudan simply, like at first, you can see that Sudan tried to show that he would be cooperative, but then 2 years later he just refused to respond to requests of the prosecutor and even publicly announced that he would not cooperate with the court. And actually the title of my presentation was inspired by this response from the Sudanese government to a request of the ICC, where the government just said that the ICC is under the shoes of the Sudanese government, which it's very courageous to say. So in the consequence of it, there was a deterioration in relations, and this made further cooperation impossible, but actually the whole procedure came almost to a standstill, but well, you can even say that the whole procedure from the beginning was based on a lack of cooperation. So the prosecutor, well, has done what he could. But there we can see that the prediction of the complementarity paradox, as has been mentioned by Paolo Benvenuti, became true because he said, why would those states generally unwilling to carry out investigation or prosecution be subsequently cooperative with the court? That's the whole paradox. And the Sudanese case, sure, cannot be seen as a general illustration of complementarity, but it is a demonstration to the limited means of the ICC in case of a lack of cooperation. So, to conclude, I will just say that the question remains open about if and how the means of the ICC can be expanded in order to assure justice more effectively and save the ICC from under the shoes of states as Sudan and to a safer autonomous ground. Thank you very much.
Thank you for your presentation. We finished this presentation, and now we have time for short discussion. If we have a question, welcome. Yes? Please.
Thanks a lot to all speakers, of course, for very interesting presentation speeches. And I have a question to Mr. Fesefeld. You said about the German Code of International Crimes. So do you think that this code and the prosecution processes in German can help Ukraine, if they really can?
There's an interesting fact. It's something like, I think, 2 or 3 years ago, the federal prosecutor also mentioned that perhaps Germans who went to Ukraine, especially to the East Ukraine, to fight there, may be prosecuted. But so far, none of these trials have, investigations have shown up. So just a specific answer, yes. So and I think that Ukraine would be able themselves to handle such German idiots who think a war of another nation is their problem or something, yeah. A more general question, of course, I think it's not, of course you can always conduct such trials better as Germany is doing them, but I think many other nations could learn of this approach my country is trying to do, and especially has to do. So I think Ukraine is perhaps some 3 or 4 steps behind Germany. I mean, it hasn't even ratified the ICC statutes, would be something like the groundwork for a national criminal, international criminal statute, but so you could, yeah, it's a shame that it's all only in German, so trial language in Germany is of course German, so it's always difficult for foreigners, because international criminal law language is basically English or a little bit French, but obviously not German, so it's always difficult for other nations to learn from it because of the language barrier. But apart from this, I think, of course, Ukraine could learn of this approach.
Thank you. More questions? We have a question.
I have a question to Dr. Fesefeld. You mentioned the 150 investigations against international crimes in front of German courts. So could you maybe from a political perspective tell what the interest of Germany is to have all these investigations?
So the interest of the prosecutor in Germany is he's bound by the law, and if he has to conduct a trial, I mean, he just follows the law. This is how German thinks about the idea of law. Yes, and what the general idea of the politics was behind creating such a structure and such a law and such a federal prosecutor who does conduct such investigations is of course that Germany, I mean it's easier for Germany than for other nations because it's a very rich and powerful state. It's obviously easier because we have the resources, but the idea of course for Germany was that they want to set a positive signal to the world, and probably they also, cause some of the the greatest war criminals in human history came from Germany. Probably this was also, of course, an answer to these happenings in the history.
If we haven't questions, we will close our first panel, and now we have presentation of the truth hounds. Thank you.
Dear guest colleagues, yeah, it's here. We are very glad to be here, and my name is Victoria Babi. This is my colleague Europolk, and we are the members of Ukrainian non-governmental organization Truth Hounds. As you know, we are here to present our work of documentation of war crimes at the east of Ukraine and the Republic of Crimea. The next slide, please. We will talk about our organization and our work. We was established as an organization to combat impunity through the monitoring, documentation and investigations of human rights violation and war crimes. So next slide, please.
The third page, please. And then the next. Yes.
As you can see, organization was established, and we started our work as a group of activists in Georgia. Our main tasks are the collecting of the facts, evidences, and the other relevant information. We analyze it and prepare the documents due to requirements and standards of International Criminal Court and European Court of Human Rights. Please, the next. Some interesting facts about our team. We sent two submitted communication to the ICC from September of 2014, and the third communication is planned now. And we spent more than 10,000 hours of documentation in conflict zone, and 20,000 kilometers inside the conflict zone and around it. Sometimes we have difficulties, and our techniques tell us stop, we need to rest, and sometimes combatants are not happy to see us, and we waste a lot of time on checkpoints and in the field. When we talk about our field mission team, we usually use avatars and call signs because of security reasons. So this is first three. Remember? You can see their call signs and avatars. The next, please. And the other one. Yeah. And the next, please.
Yes, we had a great team because our logo is a dog, watchdog of International Court in Ukraine. So I think we look like them. We look like these dogs, and it's much easier to work when less people know how you look like. If you want to travel to Crimea, for example, and not to get to FSB, you need to be secured as much as possible. The same stuff in the Donbass region. Not always, but there's a conflict zone, and it's always some problems in the conflict zone. So if nobody knows you, that's much better. That simplify your work. I would like to tell you a little about the documentation, how we document war crimes and crimes against humanity. I would like to start from the most important stuff in the documentation, like confidentiality. When we work with witnesses and victims, they are already extremely traumatized, and we do not want to traumatize them more. But we need their statements. We need to prove some things that we need to prove. So we always tell them, and we always prove this, that all they will tell us, we will only bring to the ICC, and all their personal information like names, telephones, and other stuff, addresses, will be coded. And we always code them. For now we have like 800 statements, 800 cases documented, and all of them are coded. Nobody knows the name of the victim or witness except us and the prosecutor who works with the submissions we send to ICC. It's always important to tell the person, tell the victim how we document, because yes, the next slide, please. Because simple civilian, they doesn't know nothing about the rule of law, about the ICC. Who knows what the hell is this ICC? Because it's somewhere in The Hague, and the witness in Avdiivka, Donetsk Oblast. Yes, who knows the ICC? So we always need to explain the person for what we do this, how we will find the perpetrator, how we work with this information. That's the big stuff of the conversation between documenter and the witness or victim, but it's extremely important because when the person knows what you do, he or she will explain you the facts he knows in the most effective way, and it will be much easier later to use it to analyze and to write submissions, write reports, to make advocacy activities. The next slide, please. Yeah. Excuse me. There are the most important questions you should find the answer during the documentation. You may see on the slide that it's like in journalism, it's like in every reporting and investigation, you should find who, when, where, how, why, and so what. What happened after this? The who question is, I cannot say it's extremely important because all of them are extremely important, yeah? Who question? We need to find the information about the perpetrator. If the person knows the call sign, that's great. If the person knows the name, that's absolutely great. But in most cases, the person doesn't know anything about the perpetrator, even if in case of tortures, in cases of inhuman treatment, victim doesn't know anything. Sometimes the person cannot even remember how the perpetrator looked like, what color of hairs, anything. So in this way, you should ask as many questions, personal questions, as you can. Maybe there was some tattoos, maybe there was some scars, maybe there was anything, maybe he wore, I don't know, t-shirts except of anything. So anything unusual then can make the person to remember how the perpetrator looked like. And after that, we can find the information about this person using social media. If you know at least anything from different victims and witnesses, we can find the perpetrator. That's really hard. But it is possible if we have as many information about the who question as possible. Then the when question. Sometimes the victims and witnesses, it's hard for them to remember when something happened. Even if the torture was a month ago, not everyone who was tortured will remember was it Monday or Tuesday or it was 8 a.m. or 8 p.m. and you need to find this information, but you need to find it, and it's really important to find this information to show all the steps of the investigation later. So you should ask, was it rainy? Maybe there was a football match that day. If it was a football match, who came? Who played? Was it sunny? Was it cloudy? Anything that can help you to find the exact date, exact time, at least with minimum problematic changes. Yeah? You should find the location where, because if you cannot find the answer for the who question, by finding the where question, you can examine the group who could make the crime. So, and if you know the group, that will make it easier to conduct further investigation. The next, please. Yes, the question how. The question how is the hardest one for the documenter, always the hardest, because, for example, you work with torture, and you need to find all the information of how the person was tortured, with all the instruments, all the body parts that was tortured, all the psychological impact of the person that was used. You need to find all the details of the extremely traumatic experience, and with the thought in your head that you cannot even think about make this person more traumatized with your questions. So you need to be some kind of psychologist and to get into one's mind without traumatizing more. For this reason, we use some techniques like maps writing. We ask the person to write the map of the basement where the person was held, because when the person writes something, draws something, it makes the person easier to remember traumatic experience and to tell about it. Important question is also why. Why the person was tortured, or why someone was killed. Was it a combatant? Was it a religious person and he or she was tortured because of religion? Was it a simple civilian who just came to a wrong place in the wrong time and he was catched and was tortured? Why he was tortured? What is for the reason to get some information about the enemy? What is for the reason just to make a pleasure for the perpetrator? What was the reason of being tortured? What was the reason of the shelling? For example, shelling is not always a crime in discrimination. Yes, because yes, it's always the crime, but it's not always obvious who is the perpetrator. Because shelling was, for example, on the case of Ukraine, shelling could be realized from the territory of Russia Pact separatists, but in the area, in the civilian area, there could be Ukrainian armed forces base. So who is the perpetrator in this case? The armed forces who made the base, or the militants who shelled the civilian area? And we need to find all this information just to check it later and to find out who is the perpetrator, who is the real perpetrator. And the last but not least, so what? What happened after the torture? The impact of the person. Psychological impact. Maybe the tortured guy or the person after the shelling came to a psychologist and had a need to eat some pills for the head, I don't know. Maybe there was some traumas, physical traumas, and it's always the impact that's shown the seriousity of the situation that happened during the crime. What about documentation and personal information? I would like to show you that the screenshot from one of our submissions. All these numbers are different people who are coded in our base, and that's the only way we use their information. Of course, we should use it, we should talk about it, but we can never talk about their names, so we always code them. So the guy 0087K605 is the real guy from the file 87 who was, I guess, tortured, or it was inhuman treatment against him, yeah? And this real person who gave real testimonies, who signed the testimonies, who signed the power of attorney for us, who told us and proved that everything he told he could prove in future, in courts everywhere. And we use this information to submit to the ICC to make our reports. Evidences. To collect evidence, there should be a procedure to collect them. For example, when we work with shelling, we always have some roulettes to examine craters, and compasses to find out from where the shell come from. We have different techniques to understand from which part of who could make a shell, who could, yes. The next, please. That's the example of the hand-drawn map. You may see that. The next, please. Yeah. It's not only psychological technique to draw a map, because sometimes it helps to examine, for example, the basement. In most cases, we cannot get to the basements in Russia Pact separatist territory, yes? Because they are closed, and it's still tortures there. So we asked the person who was there to draw a map to show how many people was there, in what cameras, in what rooms they was held, what happened in which room. So when person draw this map, it's this one, yes, with lots of tables. When the person draws this map, she or he remembers everything. And it's much easier to show them, oh, in this box was the perpetrator number, blah, 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 and he did that. And in this case, it's really much easier to document. On the other map, we can see the hand-drawn map of one of our witnesses. It's about the shelling from the Russian territory in 2014 using BM-21 Grad. This shell was conducted from the Russian territory, and I will tell about it a bit later. But on this map, you may see all the details: where is the city, where is the border, where were the positions from both sides. From both sides, yeah. The next information I would like to tell you, please, the next slide, is about submissions. The first submission was, the first communication was submitted in October 2015. It contains 300 plus cases, among them are 83 cases of tortures, 133 cases of indiscriminate shellings, another cases of grave human rights violations. It was really important for us because it was our first experience of submitting evidences to the ICC, and we were very happy because Office of Prosecutor told to our lawyers that this submission is great, so some kind of publicity for ourselves. The next submission was about the Crimea and international crimes in Crimea. We spent a couple of field missions to the Crimea to document, to talk to Crimean Tatars about the crimes committed against them, what did the FSB, what did some called ополчение, militia. So we collected evidences of 36 cases of tortures, which is extremely violent in this case. 15 cases of disappearances, and nobody knows where these people are. I guess no one will never know. 7 cases of murders and 90 cases of unlawful detention was documented, and lots of cases of forcible displacement and appropriation of property. But they are not so serious as torture, murders, disappearance, and other stuff. So we also submitted it. The last, but also not least, and not only our report, is the next one, please, and the next, yeah. Where did the shell come from? It was our report, which is the example of a good luck of our team, because you cannot document if you are not very lucky. In 2015, we decided that not only we, yes, the next place. We decided that we need to prove the international character of the conflict, because still it is not proven correctly, and the ICC cannot tell that the conflict in Donbass is having an international character still. That's why we had lots of missions to Luhansk Oblast to document shellings in 2014 from that we thought, but did not have proofs, from Russian Federation. We collected lots of witness statements from civilians who didn't know each other, from border guards who didn't know civilians but gave the same information. So we proved from different sources that those shelling, first of all, really occurred, and that those shellings were from the territory of Russian Federation. We got some examples of military interventions from Russian Federation to the territory of Ukraine, not only shellings but also military intervention, which is absolutely cruel from their side. After that, we analyzed that question, these statements, and thought, that's possibly not enough to prove the international character, because the stuff is really serious. We decided to look, the next slide, yeah? We decided to look for some maps, and it was a great luck, because on Google Earth, according to our witness statements, on the same dates, there was photos proving the witness statements. For example, on the 2 big photos on the left side, you may see the same area in different dates. On the one photo, on that one that is on the lower side, you cannot see the tracers. But on the higher photo, you cannot see the tracers from the from launchers. From launchers. On the other maps, you can see on that one map, could you please just take it a bit higher? Yes, a bit higher, just a little. No. Yes, and okay. On this picture with the yes, it's cut. On the cutted picture, you can see 5 launchers in the area about which our witnesses told us. Could you please, yeah?
You can see the arrow, yeah? Do you? It's 5 units.
Yes, we found 5 units on the map and found a lot of craters, and that was really lucky because usually if you order these photos from satellite, you must pay 2,000 USD. Yes, 2,000 USD for one photo. But it was extreme luck because the satellite was in exact time, in exact place, and just found and proved the witness statements we got from the field and proved the big part of our work. So then we made this report, and with other witness statements, it will be submitted to the ICC this year. And I hope it will be enough to prove the international character of the conflict. But we still work on this question, on this issue, and try to prove as many as it is possible. So I think that's all about the documentation process we make. And if you have anything to ask us, we will be happy to answer. Yeah.
My question is very simple. How to become a member to your team?
That's an interesting question. If you'd like to travel to the conflict zone, you may become our volunteer, and we will teach you anything we know, because it's always hard to work for all this time and regularly. Because, for example, for last 2 months, I spent 6 weeks in conflict area. So from 8 weeks, I was only 2 weeks at home, for example. So it's always hard to work in that area, and if you have psychological power to do it, we're always happy to visit new personals who can document and who can work with us. So if you want to, you can find our website, truthhounds.org, or you can just ask me a visa card after this conversation, and I will give you our contacts, and you can write us. If you have anything else to ask, please.
Now we are approaching the closing part of our conference, but now we will have still one event, a presentation of the textbook of international criminal law written in Ukrainian, and the presentation will be held in Russian. Before starting of this book presentation, I would like to add maybe some few words about Truth Hounds. Actually, Truth Hounds is one of the most important players in Ukraine that collect evidence for international document international crimes in Ukraine. I have the honor to be a legal expert of this organization, and I write a legal opinion concerning the evidences this organization collect in their field missions. I think that they are doing a very important work, since International Criminal Court usually base its decisions, its investigation and prosecutor-based its investigation on the evidences collected by a non-governmental organization. And in this sense, Truth Hounds do very important job, very important work for the documentation, for the success of Ukrainian case in the International Criminal Court. So thank you very much for this presentation, for very new perspective on the international criminal law from the field missioner, from the field perspective. I'm very glad that you were able to come and to share your mind with us on all these issues. And now I will switch to Russian to start the presentation of the book, and in a half an hour, maybe in 20 minutes, we will have the closing part with certificates and all these things. Книга, которую мы сегодня хотим презентовать, это учебник по международному уголовному праву, который называется «Теория и практика международного уголовного права». Он был подготовлен под общей редакцией Натальи Анатольевны Зелинской, которая была и вдохновителем, и автором большинства материалов в этом учебнике. Это, по сути, первый учебник на отечественно, не только в Украине, на самом деле, но и на территории бывшего Советского Союза, СНГ территории, да, настолько современный учебник по международному уголовному праву. Было, конечно, несколько учебников в 90-х годах, известный всем учебник Лукашука, который был написан еще в 90-х, и этот учебник на самом деле на сегодняшний день уже не отвечает тому представлению о международном уголовном праву, которое сформировано и в доктрине, и в практике. Поэтому для нас было очень важно, и для Натальи Анатольевны в первую очередь было очень важно пересмотреть старые подходы, обновить их существенным образом и представить новое современное видение международного уголовного права. Я чуть позже затрону те вопросы, расскажу о тех основных концептах, на которых базируется этот учебник. Но перед тем, как перейти к ним, я бы хотел предоставить слово Николаю Ивановичу Пашковскому, который тоже был у истоков в определенном смысле этого учебника, потому что он обсуждал с Натальей Анатольевной многие вопросы, которые находятся в его основе. Николай Иванович, пожалуйста.
Хочу прежде всего сказать, как преподаватель, который многие годы участвовал в преподавании таких курсов, как международное уголовное право, международное сотрудничество в уголовном судопроизводстве и международно-правовые стандарты в сфере уголовной юстиции. И сказать, что действительно вот основная трудность, когда сталкиваешься с тем, что студенту необходимо дать какие-то первоисточники, прежде всего теоретические первоисточники. И основная трудность заключалась в отсутствии учебника. И долгое время такой учебник по международному уголовному праву, современный, актуальный, отвечающий всем современным тенденциям развития международного уголовного правосудия, была монография Натальи Анатольевны «Международные преступления и международная преступность». И для меня было удивительно, что по настоящее время на просторах СНГ, бывшего Советского Союза, отсутствует учебник высокого уровня, который бы отвечал современным тенденциям развития этой сложной, новой и очень важной сферы международного уголовного и международного публичного права. И я нахожу, что это было большое мужество Натальи Анатольевны, коллектива соавторов, принять на себя ответственность, написать такой очень важный учебник. И, безусловно, здесь и лидером, вдохновителем и человеком, который продвигал вот эту идею международного уголовного права в нашем университете. Человек, который основал современную школу международного уголовного права в Украине и руководил все время школой международного уголовного права у нас в университете, была Наталья Анатольевна Зелинская. То есть это как раз тот случай, когда роль личности в истории определяет развитие, в данном случае, науки международного публичного права. Да, в Украине многие занимаются, и, я надеюсь, будут заниматься проблематикой международного уголовного права. Но человека, который настолько глубоко разбирался в этой сложной материи, человек, который мог вдохновить соавторов, и не только соавторов, но и большую кафедру международного права и международных отношений университета на изучение международного публичного права и уголовного права, была Наталья Анатольевна Зелинская. Поэтому в определенной мере вот эта первая конференция, которую мы проводим в университете по международному уголовному правосудию, она посвящена в первую очередь Наталье Анатольевне Зелинской, которая думала о такой конференции, мечтала о создании Центра международного уголовного права и правосудия. Я думаю, что мы реализуем и эту идею Натальи Анатольевны. И, к сожалению, в феврале вот Наталья Анатольевна ушла от нас, но мы видим, что ее идеи продолжаются, и я студентам, безусловно, коллегам буду настоятельно рекомендовать почитать. Это уникальное, действительно уникальное издание. И я верю, что в ближайшее время выйдет и второе издание, учитывая, что Международный уголовный суд и трибуналы ad-hoc не перестают работать, и их роль только возрастает. Да, и открываются новые смежные сферы, причастные к международному уголовному правосудию. Поэтому я думаю, что вы обязательно увидите и продолжение вот этой идеи Натальи Анатольевны Зелинской. Спасибо большое за внимание.
Спасибо. Спасибо, Николай Иванович. Я бы следующим хотел предоставить слово Виктору Николаевичу Дремину, доктору юридических наук, профессору, заведующему кафедру криминологии, и супругу Натальи Анатольевны Зелинской, который знает из первых уст о идеологии этого учебника, о том, почему и как он появлялся.
Спасибо. Я хочу принести извинения, во-первых, что я не присутствовал на конференции, но были достаточно уважительные причины. Вот я сегодня сумел присоединиться к вам и очень рад и тронут, что сегодня звучит имя профессора Зелинской Натальи Анатольевны, с которой мы прошли жизненный путь в течение 40 лет. И на моих глазах, мы в глазах друг у друга формировались как ученые, занимались разными науками, я криминологией, она международным правом, международным уголовным правом. И знаете, вот я хотел бы подчеркнуть, что несмотря на сложности, которые были в ее жизни, и особенно последние месяцы, она очень много работала над этим учебником, и это был ее действительно проект такой, и который она вовлекла своих учеников, очень талантливых, молодых ученых, одним из которых является, она считала, выдающийся перспективный международник Дмитрий Коваль, блестящий ученый, очень перспективный, который внес очень большой вклад в издание, вот уже на последнем этапе, в издание этого учебника, в редактирование его. И я хочу, вот памятуя наши разговоры и беседы с Натальей Анатольевной, сказать слова благодарности Светлане Андреевиченко, еще одному автору, профессору, доктору юридических наук, который является соавтором и очень много сил приложила к изданию этого учебника. Здесь одним из авторов является еще один ученый киевский, Дремина Волок. На сегодня тоже не может присутствовать по объективным причинам. Но вот этот коллектив небольшой, но слаженный, он сделал все возможное, чтобы работа была завершена. И, безусловно, она невозможно было бы издание без нашего главного издателя Тимура Робертовича Короткого. Очень благодарен, Тимур Робертович, вам за то, что вы вот все делаете всегда качественно, в срок, и все издано на самом высоком уровне. И этот учебник, я думаю, что он будет пользоваться и с вашей помощью популярностью, может быть, и переиздан, если он получит признание. Я очень признателен и хочу передать слова признания, потому что Наталья Анатольевна очень тепло отзывалась о профессоре Гнатовском Николае Николаевиче, и профессор Микиевич, профессор Денисов, профессор Стрельцов, это рецензенты и советчики, и Николай Николаевич Гнатовский, с которым они состояли в дружеских отношениях, он очень много сделал и повлиял на ее мировоззрение, в том числе вот на концепцию транснационального уголовного права. Поэтому спасибо всем участникам конференции, что сегодня прозвучали такие слова и вспомнили Наталью Анатольевну Зелинскую. Вот. И я хочу уже как ученый, как преподаватель вуза пожелать всем успехов в научной работе, в разработке чрезвычайно сложной проблемы, которой посвящена была ваша международная конференция, которая, к сожалению, глубокому, перспективно, глубокому сожалению. Вот. Хотелось бы, чтобы этого не было, но здесь, безусловно, открываются очень большие, так сказать, международно-правовые, вскрываются проблемы, они требуют решения. Большое вам спасибо всем. Спасибо, Дмитрий.
Спасибо большое, Виктор Николаевич. Я буквально еще в нескольких словах о главных идеях этого учебника, на которых он базирован. Ну, во-первых, это я знаю из своего преподавательского опыта, очень сложно всегда начать преподавание международного уголовного права из-за того, что студенты часто смешивают понятие транснационального уголовного права и международного уголовного права stricto sensu. Этот учебник принципиально разграничивает эти понятия на основе двух формальных параметров. Параметра криминализации и параметра юрисдикции. Уже исходя из этого формулируются дальнейшие темы учебника. Большая его часть посвящена международному уголовному праву stricto sensu, то есть международному уголовному праву Международного уголовного суда и ad-hoc трибунала. Очень важно, что Наталья Анатольевна, эта часть как раз была написана ею, выделила и определила особенности так называемых модификаций международных преступлений. Нюрнбергской модификации международного преступления, то есть как оно было сформулировано в уставе Нюрнбергского трибунала и уставе Токийского трибунала. Так называемой Гаагской модификации международного преступления или модификации, которая нашла воплощение свое в уставе трибунала по Югославии и в уставе трибунала по Руанде. И так называемой римской модификации международного преступления, которая уже была материализована в Римском статуте. Этот учебник, кроме теоретических вопросов, касается и вопросов практических, в том смысле, что он анализирует практику, последнюю практику трибунала по Югославии и Руанде и Международного уголовного суда. Кроме того, в своей завершающей части он анонсирует, возможно, следующее издание, которое тоже во многом будет базировано на работах Натальи Анатольевны, которое касается транснационального уголовного права. У Натальи Анатольевны была мечта издать такой учебник, который был посвящен международному сотрудничеству по уголовным вопросам. И последняя 7 глава как раз посвящена этому транснациональному уголовному праву, то есть сотрудничеству по таким вопросам, как борьба с пиратством, борьба с незаконной миграцией, борьба с торговлей людьми, с киберпреступностью и некоторыми другими преступлений. Одним из очень важных и принципиальных особенностей этого учебника является то, что он не чисто международно-уголовно-правовой. Он во многом включает исследование вопросов криминологических. Наталья Анатольевна в своей монографии еще по мотивам докторской диссертации подошла к вопросу международной преступности не легалистски, но с учетом тех социальных последствий, которые такие преступления провоцируют. И этот же подход реализован, собственно, и в данном учебнике. Кроме того, еще одной важной характеристикой является то, что здесь затронут крайне важный, до сих пор неразрешенный вопрос политической преступности, так называемый. Исследованы его истоки этого концепта и современное состояние идеи политической преступности. Это очень важно, потому как сам концепт политической преступности очень серьезным образом влиял на сотрудничество государств самого раннего периода по уголовным делам. Достаточно сказать, что один из первых известных нам письменных источников международного права, договор между Рамзесом II и царем Хетов, он касался, собственно, политических преступлений. Потому что в этом договоре речь идет о взаимной выдаче хетов и египтян друг другу для того, чтобы их могли преследовать их руководители, царь, соответственно, и фараон. И на самом деле фараон и царь хетов не были заинтересованы в выдаче любых преступников, которые совершали обычные преступления. Они были заинтересованы в выдаче исключительно тех, кто мешал их правлению. То есть этот первый договор, по сути, касался именно политических преступлений. Это проявляет, насколько важна эта концепция была с самого начала и до сегодняшнего момента она сохраняет свою важность, понимание того, что есть политические преступления, как они влияют на применимость, эффективность международного уголовного. На этом я хотел бы завершить. Я думаю, что вы сможете ознакомиться с содержанием этого учебника позже, и дальнейшие мой анонс дальнейший не является необходимым для того, чтобы сделать понятным содержание учебника. Мы договорились с издателем его, что сегодня при выходе из нашего зала возможно будет приобрести этот учебник по цене, которая будет отличаться от цены в магазинах, поэтому, в принципе, если у вас есть желание и вы ощущаете потребность в более полном понимании международного уголовного права, либо изучении его, вы можете приобрести учебник в фойе этого зала. На этом я, наверное, бы хотел закончить презентацию и перейти, собственно, к официальному закрытию нашей конференции, поэтому я перехожу обратно на английский. So now I would like to pass to the official closing ceremony. I don't like this word; it's too official. It seems to me. But still, I would like to thank all of the participants for coming to Odesa, for sharing their minds, for active participation in the discussions. I hope that all of you got some new information, some ideas for future elaboration, for future study. I would like to express also gratitude to the organizational team that helped, that actually made this event possible. First of all, my gratitude goes to our beloved head of the International Law and International Relations Department, Mykola Gnatovskyy. Thank you very much for helping to inspiring this very event. Also to two colleagues of mine who are not present here, Dr. Konstantin Gorobets, who is now conducting his research in Groningen University in the Netherlands, and another one, Alexei Plotnikov, who is unfortunately got pneumonia and was not able to participate unless he was planned as one of the moderators of the conference. And also, I would say the words of gratitude to our volunteers that are one of the best students I ever had, Yulia Zhuraved and Victoria Muzika. Thank you very much for helping with logistics, with caring about our guests. And before we will proceed to the certificate part of our closing part of the conference, I would like to ask our distinguished guests maybe to reflect on the conference in just a few words. If I may, Judge Ušacka.
Thank you. 2 days passed very quickly, so we are at the end of the conference, and I think we had a great time. We were not bored at all, yeah? And every presentation was interesting, useful, and gave us thoughts to think further. And I think what we need to understand as lawyers and non-lawyers, what important in our life is to learn. You never say that it's enough. I know everything. It's not possible. Yeah? And I would like to thank organizers for this wonderful conference. It's brought together people from different countries, different organizations. I was touched today by presentation of this NGO, because I think what even judges and lacking in international courts and national court, to see these people who are helping to collect evidence, to hear these stories. Because what we see judges in the papers of the court, we saw only papers, yeah? We don't see even these pictures and everything, how this evidence is collected. And thank you very much for your job, and I think there will be more volunteers. If I would be younger, I will join this, because it's really what is very, very important. And already I told you, I also was impressed by this presentation of this book. I will buy this book for sure and will ask for some autographs. Unfortunately, I did not met Professor Zelinskaya. It's very, very pity, because I think we would have with you a wonderful conversation, yeah? And it's amazing what can the person working in the field, the academic field, to develop the science, to develop doctrine of international criminal law, and to go inside. I think it's very, very good. But maybe its time will come that it will be translated also to Russian, to more people to read this book. And last, have a very nice day today, yeah, and all the best in your lives, and I hope we will meet again. And the best wish in my life still to see some of you, many of you, who will go up in their careers and achieve their goals, yeah, at the beginning, maybe not so big, but with time, yeah, because this is most important that you have this in heart and you want to work, and it's interesting for you. Thank you.
Thank you very much, Anita Arturovna. As always, you spoke from the bottom of your heart. It's very warm and very good to have such a closing speech. Dr. Wilkitsky, if I may, I would like to ask you for a few comments as well.
Thank you very much. Like yesterday, I would not be so ambitious to see myself on the same level as the previous speaker, who happens to be my wife. But I also was here in a different quality. I was here as presenting some aspects of my domestic law and of my domestic practice. I do have the impression today that this was useful not only for me, who I learned a lot, but also for some of the participants, and I feel confirmed in my conviction that just seeing the practice of other states, not necessarily learning from it, but seeing and comparing with their own situation, their own practice, helps a lot. And I told you that it's not arrogance when we say that Germany did a lot in this field, and we would like other states to be inspired by that, not because we think we are better, but because we think we did invest a lot of thoughts, of efforts, and other states should see that. And we are very happy that we, once in our existence, we can maybe also serve as a positive example. And so, to all of you, I just join the wishes of Judge Ušacka, saying that it seems also to me that here's a collection of the finest young legal minds in Ukraine, and I'm as sure as her that maybe not me, I'm too old for that, but the middle generation will see some of them in the next 20 years come up to higher and better, to higher offices, and can make use of what they learned in a long academic career, including conferences like that in the future. Thank you for giving me this occasion, and thank you for organizing this conference.
Thank you, Dr. Wilkitsky. I will repeat Mykola Gnatovskyy. In this regard, you are too modest. Your contribution was very significant, and we really appreciate that you were able to come to Odessa and to participate in the conference. And now I would like to pass the floor to the representative of this very university, to Dr. Vyacheslav Tudakov, whom you met yesterday during the second panel discussion.
Well, I don't know what I have to do now. I guess, as usual, time is limited in the case of well, inspiration of any representative of state organs or any representative of university is connected with only one idea: the sharing of certificates. That is why I want to say very great things from all of the Joint Chief of Staff of National University Odesa Law Academy, especially from our President, Mr. Kivalov, for your attending the conference, for your sharing your ideas, and for your brilliant mood. Just trust me. When yesterday I have the possibility to speak with you more than an hour, there is a great energy which flows from you to me and from myself to you, because that is the case. We are creating a new kind of truth. And the new kind of truth is connected with the idea of international criminal justice. I'm very thankful to all the organizers, especially to the Department of International Law and International Relations, for doing that. Thank you, and I hope that it would be not only the only one conference. Sometimes it's very interesting to begin, but it's very hard to make a next step. I hope that it will be not only the next step, but a very great path to a success. So, congratulations. Very, very happy to say a warm hello, and I hope that you will attend the next conference next year. And maybe we will start to share in the certificates. It will be better. I don't know how could we do that.
The first one is Victoria Mozgova.
That is Victoria Mozgova. Congratulations.
you.